leading the way.
Well,
Natasha knows what she's doing. There is no order of the court to declare that she should be recalled. There is no order. What the court said, and I have both the copy of the CTC and the full judgment. The full judgment came out last week. I've read both the CTC and the full judgment.
that's the true.
The court said the Senate should consider.
The word used was consider.
Consider recalling. The court affirmed that punishment should not be disproportionate to offense.
Yeah.
And that, in her opinion, 6 months was excessive. But the judge also knows that there is separation of powers and that the legislature has power to punish infractions by its members. So the judge didn't want to appear like she's interfering in the running of the legislative arm, because the law gives them that latitude to punish infractions by their own members. In fact, in Aliun Dume versus Senate President and others, a case decided by the Federal High Court, the court ruled that the Senate can punish its members as long as it conforms with the laid down rules, guidelines.
Yeah, okay.
So in this case, there is no, all of the cases that Natasha brought to the court were resolved against her. All. In the first place, she said that her matter shouldn't have been taken before the, what was it called, the Senate Committee on Ethics, the Ethics,
Ethics Committee.
Petitions and all that, that's Ethics Committee. The court ruled that it was within the administrative powers of the Senate President to refer the matter to that place.
To go there.
She also said she was not allowed to talk, and that was an infringement on her rights. The court ruled that by the rules of the Senate, you can only speak from a seat assigned to you.
Yeah.
You know? The court also ruled that the Senate President had the right to reassign her seat. There was not a single matter that Natasha brought before that court that was not resolved against her. But immediately she came out, because the judge made what is called obiter, or a passing statement. The language of an order for anybody who went to school is definitive, is clear. I hereby direct that. But where a judge says it is, in my opinion, the Senate should consider, that means she's giving to the Senate the latitude to recall or not recall.
It was not an order.
See, the court, all of those media commentaries and legal punditries suggesting, that she was recalled. Okay, now, and even in her appeal, I've read her appeal. I've read the appeal of the Senate. Some people argue that, okay, if the Senate didn't lose the case, why are they appealing? Senate is cross-appealing. A cross-appeal is usually in response to an earlier appeal. The Senate is, in the first place, Senate said that court did not even have jurisdiction. Senate is trying to make sure that they see whether the appeal court can rule that in the first place, Justice Binta Murtala Nyako shouldn't have even entertained the matter.
Yeah.
Because the rules of the Senate, which the judge also admitted that if they have to intervene in all matters that happen within the plenary, that the court will have no other things to do. So they give to them the right that matters decided in the plenary remains there, should not be contested in court. Is one of the grounds upon which they are appealing. Let me see, look at some of those appeal. Okay. Natasha had appealed before the same court, so the cross appeal is not against the entire judgment.
Okay.
But the court dismissed the preliminary objection of the Senate that it should not have entertained that suit.
Okay.
So they are going before the appeal to say that in the first place, that case shouldn't have been heard by the court. That's a matter of jurisdiction. So, but the Senate is also saying that the Federal High Court has no jurisdiction to deal with the issue of privileges of a senator. So the Senate is saying, citing the case, then the judge cited the case of Aliu Ndume, and where the Federal High Court held that the Senate had the right to punish its members provided that due process was followed. The court ruled that Senator Natasha's invitation to appear before the Senate Ethics Committee was an exercise of procedural fairness. I'm reading from the judgment now, and not a breach of it. The court then said, most significantly, listen to this, there exists no allegation whatsoever to the effect that the defendants contravened a statutory or constitutional provision. You know? So, Natasha, according to them, still talking about why they went to court, because Nigerians are saying, oh, they went to court because that order was there. But they are saying Natasha refused to exhaust all internal mechanism for resolution before going to court, because the rules of the Senate says you must exhaust all avenues for internal resolution before going to court. So before going to court, you must present a complaint with 3 months notice to the clerk. They are saying she didn't do that. She just went straight to court and all that. The Senate President's right to fair hearing was breached as far as they are concerned. The issue of duration of suspension was not before the Senate. You know, Natasha went to court even before the sitting began. She refused to face the panel, went straight to court. So they are saying now that even the court shouldn't have mentioned the duration of the thing, because it was not even, the issue was not before her. It
was not contentious.
The issue was not before her. It couldn't have been before her because she was suspended after she filed the thing. So they are saying that the judgment held in, that the judge erred in law by making a recommendation, whereas she has not asked the court to do that. And then they are saying under section 251 of the Constitution, that the finding that the 6-month suspension was excessive, overreaching, was wrong. That the judge shouldn't have even made any recommendation because that matter was not before her. So, according to them, section 251 of the Constitution was adhered to, in the sense that the matters relating to the running of the legislative houses are deemed to be within their purview. They have independence
to do that,
to do that, and the matter shouldn't necessarily go to court. You know, what I've seen is, because we've had this kind of cases in the past that did not get to the highest court in the land. Once the person is recalled, then it ends there. They are trying now to see, this is the reason for this cross appeal, to see whether that matter can get to the Supreme Court, for it to be decided conclusively that where the Senate punishes a member, or the House of Reps punishes a member, it is not going to be subject to litigation. That is the point. Yes, that is the point.
Because it shouldn't be.
Yes, there was even a section of the law that I quoted. Maybe I will get it. I will see it as we move on. Justice Nyako submitted that section 36 of section 1 of the Constitution does not envisage judicial review of every utterance or internal deliberation made during legislative plenary. You know, and she said, if her court were to wade into every such matter, this honorable court will know no rest. That's quoting directly from her judgment. So I think section 251 of the Constitution also validates that. So Natasha, in her appeal, said the appeal court should nullify this judgment in its entirety. How do you ask the appeal court to nullify a judgment in its entirety and you are still holding on to an advice there and trying to use it to get... She knows that she cannot get into the Senate.
Of course,
it's just deceiving the gullible Nigerians. A lot of Nigerians who don't read.
Can we therefore conclude that she is a long way from home?
No, the thing is, I've always suggested that this matter, they could resolve it amicably. Okay. But
without this
but some of the people advising Senator Natasha continue to deceive her. Some are saying, oh, she should only write apology to the Senate. Natasha thinks that, to the court. Natasha thinks that if she apologizes, her political career is finished. Because she knows that all of those people on social media will come for her. But this is about your own political future. When Senate President Akpoti was in this kind of situation with Saraki as Senate President, once he realized that he made a mistake, he quickly apologized to the Senate President, and the matter ended.
And that's the condition of what the Senate has done. The Senate said that for her case to be reviewed, she should apologize.
Yes, it's not prepared to apologize.
It's difficult to apologize.
And are you marveled to have these theatrics going on?
That's what I'm saying.
Considering that our dear Senator Natasha Akpoti is a legal attorney. He's an attorney at law.
Sometimes.
It doesn't matter.
Do we not see people who are lawyers who come to studios to twist the law? Do we not see that? Telling us that 3 persons can run the House of Assembly? Have we not seen that here? So it doesn't matter what cause somebody read. No. It doesn't matter. Some of those lawyers, I still remember your Zubaku and I, one lawyer called us names over a matter in Abia State. He claimed that, we are taking money because we said this is how this matter is likely to end. He chose to be on the other side. By the time the judgment was given, we were vindicated. Because as I always say, judgments are written in clear English language. Yeah. You cannot say because you are a lawyer, you now twist the judgment and expect us to agree. No. If the judge wanted, why didn't the judge say that Senator Natasha consider paying 5 million naira fine? Did she use the word consider? That's the thing. I was arguing with someone. I said, the judge gave an advice that, in my view, your rules need to be amended so that punishment can be commensurate with the offense committed. He then said that, in my view, this is excessive. The Senate should consider. I have it. I think it's paragraph 12 or so. Consider. That's what she said. It's not definitive.
That's taking a second long, hard look.
It's advising you. Yes. She knows that they have the power to punish. You understand? That's the point that she's making. Realizing that as an independent arm of government, they have the right to punish. Can the NJC punish a judge now, and the governor will say, no, I disagree. You cannot punish that judge. You can't now. And that's why the dancing governor in Ondo, when he tried to remove the chief judge, all the judges who should have taken away, they were running away. And the NJC told him, no, don't punch above your weight category.
When you say dancing governor, are you not necessarily talking about Oshun?
Yes, I'm talking about the one that we call dancing governor. No,
when you mentioned Ondo, it confused me.
I said Ondo. Meanwhile, I'm not drunk.
No.
I was referring to Oshun.
Okay.
Yes, he's the one we all know for dancing. It's only one style of dancing. It's not as if it has different styles.
Oh, come on.
Only one style. So the man wanted to send the chief judge packing. NJC said, no, you can't do that.
Okay.
The person who did that, and a judge agreed to be used as acting chief judge, that judge was punished for more than 10 years.
Okay.
On suspension. That's in Lekiti. Over the Fauci matter. So judges now, they are sensible, they are wise. If you try to replace one of them with another one that you are suspended because you think as a governor you have power to sack a judge, then nobody will agree to step into that position.
All right. So the debate continues, but so the man on the street...
there is a non-existent order for recall.
And she knows that she's not going to enter that chamber.
There is no, she knows
she's not deceiving her supporters.
So the thing about Tuesday, July 26th,
she will not go there. And if she goes there, she can't enter. She's worsening matters for herself by this unruly behavior. She's worsening matters.
All right, so the everyday Nigerian watches and waits to see what happens next.
Nothing will happen. Nothing will happen. Jones, nothing will happen. There is no order for recall, and nobody will bring her in. So as simple as that.
I know that both Senator Natasha and Senate President can meet somewhere in the middle.
That is what we suggested to you.